Georgia lawyers Bob and Irreverent D talk law. Listen up for stories about how things really happen in our legal system. Who are these guys? Dwayne Singleton, Irreverent D, is a criminal defense attorney in the state of Georgia. Benjamin O. Benson, a.k.a. Bob, is a personal injury attorney in Atlanta. On today's episode...
We need to have that as our running gag. That's a whole nother episode.
Well, if you say so.
It's a whole nother episode. I hope we're not tainting a jury somewhere. It's a whole nother episode. Jury finds that I'm 51% at fault and you're 50% at fault. What do I get? It's a whole nother episode.
Now, sit back and take a listen as Bob and Irreverent D talk law.
I went to Savannah. It's been many years since I've been to Savannah. But the experience solidified in my mind this thing that we're seeing. And that is what I call the snow globification of culture. It automatically makes sense, right? Right? Like when you go to Nashville, there is a snow globe of culture all within about 4 blocks where you get the entirety of the culture of Nashville. You get to see the honky-tonk, blah, blah, blah. You know, you get to see up-and-coming country artists that are sitting there like...
The bars, everybody's a performer. Right?
Everybody's a performer, whatever. Outside of those 4 blocks, it's just suburbia. Right, it's just, I mean, there's a Best Buy, there's a Olive Garden, there's a
very
whatever.
Similar like when you go to the Bahamas.
Yeah.
There's the resort, and then there's the real Bahamas.
Then there's real Bahamas, right? And so the same thing happened. I went to Savannah, and so there's basically maybe 10 blocks of Savannah where you get this just really good sense of maybe what Savannah was like 100 years ago, but just in this little tiny snow globe of culture. And outside of
River Street down there.
Yeah, right on River Street or whatever street, and then outside of that, it's just,
Right. Just town.
Just Americana.
Right.
It's just Americana. So, well, here's to Americana and another episode. Welcome to the Bob and Irreverent D Talk Law podcast. You can find us on the Stitcher. Where else can you find us?
You can ask your smart device to play Bob and Reverend D Talk Law. It'll just start. You'll hear us.
It'll just start going.
Magically.
Right? Probably on Spotify or iTunes, maybe. But if you want to see our smiling faces and this trim body that I've been chiseling out, you can see us on YouTube.
Check us out.
Check us out. Subscribe. Look for us. Search for us. Bob and Irreverent D. IRREVERENT. Irreverent.
We'll talk about nerdy law stuff.
We'll talk about nerdy law stuff. In today's episode, we are going to talk about nerdy law stuff. We're talking about Florida.
Florida.
I owned a boat in Florida until very recently. The boat died.
I heard.
Do you remember?
I did.
You were there.
I was there
the
for
day
the
it died. You could catch that in episode 13, 14, 15, or 14, 15, 16, round about there. 14, 15, 16, you can catch us hanging out at the boat with our shirts on. Yeah.
The boat.
Yeah.
People that own yachts don't call them yachts. They call them boats.
Yeah, because we're not pretentious.
Don't own yachts. Call them yachts.
Yeah, okay. I've
right?
heard this.
Okay.
Yeah, I've heard this.
Is there a reason for that? Or is it just because you want to seem like the common folk?
I mean, I grew up in a double wide trailer.
Right.
So I would never, ever label anything that I ever owned a yacht.
Right. Right.
Because it's just like that offends my double wide trailer upbringing.
We went from a single wide trailer, the Yellow River Trailer Park in Covington. True story.
I almost did a spit take. The Yellow River?
Yeah.
That was like a joke when I was 8. Yellow River by IP Freely, right?
It used to be a racetrack, right? And they turned it into
Okay, all right.
a drag strip, and they turned it into a trailer park.
Okay.
and then moved into a garage that my dad built. We lived in the garage.
You were lucky to have a garage.
Yes.
Okay, go ahead.
Then moved to the big house.
I would have dreamed of being in a garage.
Delayed gratification, my friend.
That's how it works. But our parents gave us something that is irreplaceable despite our meager upbringings, and that is a first-class mindset, right?
I thought you were going to say emotional damage.
Emotional
damage.
Emotional damage. No, I had a great upbringing. I had very loving parents.
I did too. I had great parents. I had two great parents. Tough, strict.
You don't work.
You don't eat.
That's right. You don't eat.
Probably be in defects care today, but that's was different back then.
We growing up, we would go to the beach. I lived in Central California, in like the Dust Bowl of Central California. Like, people don't understand. Yeah, everybody thinks of California like this, this mecca for big cities and things like that. Most of California is rural.
Yeah.
Very rural.
A lot of farmland.
A lot of farmland. I grew up milking a goat. We had like chickens, like I lived in pretty rural area in California. Also, most people don't recognize that there are more conservatives, more red state conservatives in California probably than there are in the rest of the country. Even though it's only, but I mean, think about this, right?
Just population alone.
Just population alone, right? Like California is about 50 million people, and maybe a third of Californians, I could have picked better numbers. Let's say 60 million people, right? A third of Californians are red state, like rabble-rousing red state Republicans, right? That's 20 million people, Dwayne. That's 20 million people. That's twice the size of our entire state.
Right.
Right? More, or nearly. Anyways.
I heard they're all moving to Texas.
I hope they don't bring the. Well, anyways, if they're leaving California to go to a more red state, maybe their politics should be in line with the state they're going to. Right?
What kind of goats did you have?
They were Nubian goats.
We had Nubian goats.
You had Nubian goats?
With the long ears?
Yeah.
Yeah, they're milk goats, right?
Yeah, milk goats. Right.
We would raise calves off of them.
Right.
So it's nothing like seeing a 600-pound steer nursing a Nubian goat.
Oh, God. Really... you would nurse like cow calves.
We would buy calves.
Not kids. Okay.
We'd buy calves and we would
and they would be nursing off. That's just
that's
just disturbing, Dwayne.
Was very.
I can't get that visual out of my head.
My dad was homesteading before homesteading was cool. He had it figured out.
My mom was green before green was cool, because she was using right. I'm just saying, she was using recycled diapers, like cloth diapers, right?
That's the worst.
Oh yeah. Anyways, I mean, I was using cloth diapers, but anyways.
My brother used cloth diapers. I still remember.
Today we're talking about tort reform.
There you go.
Tort reform in Florida. We're going to be talking about modified comparative negligence. We're going to be talking about the statute of limitations. We're going to be talking about medical damages, and we're going to be talking a little bit about bad faith
We're
lawsuits.
in Georgia. Why are we picking on Florida? What'd they do?
Here's why. In Georgia, let me tell you, I see some of the sausage making that goes along in Georgia in terms of the law that gets made.
Right.
Right. What's happened in Florida, to give you a bigger picture, is that the state of Florida has been very, very plaintiff friendly for many years.
So, for those that don't know, we always try to break this down. What's a tort?
Okay.
To have tort reform.
Yeah.
Tortellini.
Tortellini.
Something tasty.
That means there's a lot of Olive Gardens. So a tort is a thing that I do wrong to somebody else that person can sue me for.
Okay.
Right? Now, of all of the areas of law, it's the tort
right.
that people find so offensive. We can have lawyers who practice family law with gold-digging wife that cheats on her husband, and then sues for divorce and gets
Gets $300 million worth of his assets.
and gets the house, no problem,
Right.
right?
$2 million in attorney's fees. Nobody blinks an eye.
Nobody blinks an eye,
Right.
right? We can have an argument between two businesses. We call this business litigation. I've got friends, there's an entire field of business litigation attorneys who are arguing over multi-million-dollar contract deals where they're arguing over, this was a $5 million contract and they only paid $4.8 million. We're arguing about the other $200,000, right? Nobody has a problem with that because we're talking about contracts, right? The time you get to, I'm suing my neighbor because my neighbor, their dog attacked me, right? All of a sudden we get good and pissed off or good and riled up because for some reason we have this embedded in our psyche. We have this embedded in our mind. Well, we're not that kind of people.
Right.
Right. I'm not the suing kind.
Well, I don't sue people. Bad people sue people. Good people don't sue people. Right?
That's right. But they omit, they overlook the fact that it's completely okay if you're suing over a contract.
Sure.
Right. It's just that I'm not the suing type.
In a way, you are asking for a contract to be enforced because you're trying to get the insurance company to pay a policy that they're supposed to, but you can't talk about that because we're not allowed to talk about the insurance company, or you're only allowed to talk about the damages, right?
We're going to get into that.
Right.
Yeah. But there's another way to argue it that just occurred to me as you brought that up, that, in torts, you are kind of alleging a breach of contract, and it goes something along these lines, right? If we're going to live in the same community,
social contract.
There's a social contract. That's right. Right. We all agree that you're not going to act stupid, and if you do act stupid, then you've breached that social contract.
You're not going to pull out in front of me.
Right. If you're going,
me having no way to stop.
That's right.
Hurt my family, kill my children.
You're going to run a red light. Right. We all have this kind of agreement.
Well, and people are okay with locking people up for that. Oh, yeah, they killed somebody, lock them up. But
you don't want to sue.
Was Mary's life really worth $3 million?
Oh, right. Yeah, right. We can't have that.
It's too much money.
We can't have that.
She would have never made more than minimum wage.
So speaking of too much money,
right?
Here's what happens. Florida, back to Florida. Florida for many years.
It caused so much problems.
They kind of do. I mean, just saying. For many years, the insurance companies have had a really difficult time doing business in Florida because the laws there are so slanted towards plaintiffs. And that creates a problem. In Florida, they have this thing called PIP. Okay? And PIP is like in Georgia, we have a medical payments policy. So that would be a first-party policy, and that is when I go to my agent and I say, I need auto insurance, the agent says, okay, you need liability. I said, well, yeah, because that's the law. I have to have liability coverage, right? And you need to have, that's all you're required to have. You could have additional insurance coverage that covers you if someone hits you and they're not insured. We call it
uninsured motorist.
Uninsured motorist. We've covered this
ad
nauseum.
If you don't have it, go get it.
Go see episode 10.
Right.
Anyways, you should have uninsured motorist coverage, but there's also a coverage called MedPay, right, that covers just your medical bills.
Right.
Right. And so you get injured, even it's not your fault. You get injured, you submit the medical bills to your own insurance company, they just write you a check. Okay? We routinely do that for our clients as just a matter of courtesy. We don't even charge them a percentage of that because it's their money. We prefer to let our clients get that money instead of the medical providers billing it directly, for reasons that are a whole nother episode. A whole nother episode. But anyways, so in Florida, though, there's no requirement for liability insurance. No requirement for liability. You've been quoted in this very podcast is saying, Georgia's really behind in that we only require $25,000 in liability coverage. Right. You don't think it's enough?
Yeah.
Florida, none,
zero. Take your own risk.
Take your own risk.
Lose your house.
But you are required to have a $10,000 med pay policy that covers somebody else's injuries. Okay. So generally, what I've heard happens, right, is that I rear end you. You go to chiropractor. You go to the doctor. That doctor bills my insurance company directly, gets paid directly. And then maybe you have a personal injury case for your pain and suffering, but all of your medical bills have been paid directly by the PIP, by the auto insurance company. Okay. This becomes a problem.
You think?
Politically, right? Because first of all, the plaintiffs' lawyers are like, well, hey, what about us? we can't make it.
And you've got a bunch of people that don't own anything or have anything; they're just driving around uninsured.
Right. Exactly. Yeah. But it's also driving up the costs of the medical care because the
hospitals aren't getting paid.
No, because the chiropractor knows he can just about charge anything, and the insurance company's going to have to pay it.
Oh, through PIP.
Through PIP, right? You see, this goes back to
this. There's no subrogation. There's no arguing back and forth about getting the med bills down or nothing like that.
Yeah. So this comes back to what we've discussed in prior podcasts, the third-party payer problem.
Right.
The third-party payer problem comes with Medicare. It comes with, to a certain extent, with health insurance. It's definitely here in the PIP arena. The third-party payer problem is that if I'm going to the doctor and someone else is paying, a third party is paying, I don't care about how much it costs.
Right.
And you, the doctor, don't care about the quality.
Right.
Because you're billing somebody else. Okay? That creates a problem. At any rate, it's been known to be an issue that Florida has felt like it needed to deal with for many years. But as I understand it, the lobby of the doctors and the chiropractors has really been resistant to changing this PIP thing to something else.
Yeah, they don't want lawyers.
They don't want them. What, you're going to cut us out and cut the lawyers in?
Their bills down and
that's
all
right.
This, yeah,
that's right. They can't be having that. At any rate, things got really out of control, and so the governor and the Republican legislature in Florida enacted this tort reform bill that makes these changes. I'm about to go through them with you. One, they change the statute of limitations from 4 years to 2 years. Your reaction?
I mean, that's what we have in Georgia. That's not a big deal. If you can't figure out you got a lawsuit in 2 years, I don't know when you're going to figure it out.
I mean, that's awfully an anti-plaintiff viewpoint, but I'm kind of on the same page.
I mean, like 4 years is a long time.
2 years is pretty much in line with the rest of the country.
Yeah.
Right? 4 years is really a long time.
Yeah. You think about finding witnesses and doing stuff like that. That's a long
You have a latches problem.
Yeah.
Right. Yeah. We'll talk about latches in a whole nother episode. We need to have that as our running gag. That's a whole nother episode. All right. Then they say, well, we're going to change to modified comparative negligence. I had to go back because I'm so used to the way it is in Georgia. I don't even remember what the label is in Georgia, right? Because I don't think about when you live in your own kind of petri dish of law. You don't think about as much about how the laws are in other states, and you certainly don't remember the labels that are used. But to give you the nuts and bolts version, what did we call that in school when you just read the little
Cliff Notes?
Thank you. The Cliff Notes. The Cliff Notes version is this: pure comparative negligence works like this. You injure me, but I'm mostly at fault, right? We're having an arm wrestling contest where both of us have prickly pears, or those things on either side, right? And you win, of course, and my arm gets mangled, and I sue you. And we go to a trial, and my damages are $100,000. We go into trial. At the trial, the jury finds that you're 10% at fault, but me, I'm the plaintiff, I'm 90% at fault.
Right.
I can still recover in a pure comparative negligence jurisdiction.
Okay.
Right? So I would get, in that circumstance, my damages are $100,000. You're 10% at fault. I get $10,000.
Right.
Right? So it's still money.
Right.
I could be almost all completely
1%
at fault.
at fault, you still get something, right?
That's right. I could be 1% at fault. So the people of the state of Florida decided, that's just not fair. It's also kind of not in line with most of the rest of the country.
Right.
Because
in that scenario, I mean, almost every case would have some value.
Right. Like, I mean, I'm a fan of saying just about every case has some value anyways, and we're not even in that kind of jurisdiction, right? In our jurisdiction, what is it? That's the modified comparative negligence.
Right.
And that is that if I'm suing you, I have to show that you're at least 50%.
I'm more at fault than you are, correct.
Right. And if the jury finds that I'm 51% at fault and you're 50% at fault, what do I get?
0. Bunkus.
I get bupkis.
Yep.
That's right. Okay.
Goose egg.
So my reaction to the tort reform in Florida, where they're saying, well, we're moving to this modified comparative negligence where you have to prove the other person's at least 50% at fault. I mean, what's your reaction?
I mean, it sounds very similar to Georgia. It's
right? Like stopping the baby. Right. Like, of course you have to show that it's more the other person's
I guess
fault.
my only problem is if you're not requiring people to have auto insurance and you only have PIP in place, right?
Yeah.
That these insurance companies aren't going to be paying out hardly anything on these claims.
It's hard to know what's going to happen. What I can tell you, though, is, you're going
to guarantee more litigation, I would think.
That's what happened.
Right.
We're going to get into that in just a second here. But on the modified comparative negligence thing, my response is, okay, well, join the rest of the country. We're basically all like that anyways, right? Like, I mean, okay. Doesn't move the needle. Like, I'm not outraged.
No, but if you've only got $10,000 required of PIP that only goes towards medical bills,
right?
Where's your money coming from your pain and suffering?
Well, that has to come from your own insurance policy.
Right, that they're not required to have.
Well, none of us are.
Right.
Right, exactly. So that does become a problem.
Right.
But it gets worse. Now, the parts that I'm going to get into are actually really significant. These two are not so much, they don't move the needle much for me because, well, it's been like that for us forever, as far as I can remember. Now, they're limiting bad faith lawsuits. We're going to kind of brush over that. It's what?
Bad faith?
Yeah. No, yeah. It's a whole nother episode. I was trying to get you to come along with me on that.
I forgot the joke already.
Yeah, I forgot the joke.
It's
a whole nother episode altogether. It's a whole nother
episode.
All right.
What I hate is when I'm watching these.
Yes.
And we're going to talk about it in the next episode. And
then we didn't.
And I'm like,
or he changes the order.
Oh, there's like 6 or 7 things. I'm like, we never answered that question.
You lied. You lied.
You're not Santa.
So here's the kicker. Okay. And this is very, very clever. They changed the definition of what your medical damages are. You still, all right, stay with me. I'm going to give you the punchline and then we're going to unwrap it. Okay. Medical damages means what was actually paid by your insurance company.
Okay.
Or, in the absence of what was paid by your insurance company, whatever would have been paid by Medicare.
Okay.
Or 140% of what would have been paid by Medicaid.
Okay.
Okay? All right. I'm going to repeat that. 1, what was actually paid by your health insurance company. If you
actual money divvied out.
Actual money divvied out. Okay. What Medicare would have paid.
Right.
Or did pay. Right. Or 140% of what Medicaid would pay.
Because this is what we argue on subrogation stuff all the time when we're trying to argue down medical bills at the end and trying to figure out how the money's going to be divvied out is, the hospital charged $150,000.
Right.
But they would have only gotten $25,000.
14.
Right. $14,000 from Medicaid or Medicare.
Mm-hmm. Here's what we generally know. Now, the bean counters can look over our shoulders.
So the hospitals should love this, right? And the doctors.
I don't know. Here's why. I don't know how it's going to play out. But here's what I do know.
I think it's crappy for the citizens of Florida.
Well, maybe. Here's what I do know. Generally speaking, Blue Cross, Blue Shield, your health insurance companies are going to pay about 35 cents on the dollar, right? So if I'm going in front of a jury in Georgia, I get to claim my client's actual medical bill before anybody has paid it.
Right.
Okay? So I'm going to say, for purposes of this illustration, that medical bill is $1,000. We get to go in front of the jury and say, sir, Mr. Plaintiff, you recognize this?
I do.
What is this?
That's my medical bill.
That's your medical. You get it?
Yep.
Okay. And is this a true and accurate copy of your medical bill?
It is.
And how much was it?
$1,000.
Did you, objection, right? You don't get to ask how much of it was paid.
The insurance company paid it. If
nobody gets to talk about nothing. All it is
this is the bill.
Is this the bill?
Right.
Right. Now, if I have health insurance, that health insurance company would have done this. They would have paid $350 minus $350, and then what would the hospital have done with the balance of $650?
I mean, they would normally write it off.
Yeah, they just write it off because they're required to by the health insurance company.
Well, and this is where juries get in the back room and start doing calculations on their own and trying to figure stuff out.
They're not supposed to.
Well, they're not supposed to, but they do.
They do.
And because you don't know if the insurance covered it, Medicaid covered it, Medicaid or Care did, or nobody covered it, and then the $1,000 bill is still sitting out there waiting for you to pay it.
Mm-hmm. Well, I think the problem with that, I'm sure the problem with that is us as plaintiffs' attorneys educating the juries as to their role.
Right.
We kind of stand on, like, in front of the home plate and say, look, you're only supposed to follow the law, right? But we don't really give illustrations that express that. What we should be educating the jury's members as understanding is you are the umpire, right? The parties decide how the game turns out. You're only here to make certain decisions about balls and strikes. You're not here. Love you. Sure appreciate that you're here. You're doing your civic duty to be here to call balls and strikes, just like the judge is here to call different kinds of balls and strikes. But you are not here to determine the outcome of the game, right? You're here to determine the certain balls and strikes or the certain runs that happen, right? And then the law determines the outcome of the game. But we don't hammer that in. We don't get that education into the jurors for whatever reason, okay? And some of them just don't want to hear it. Yeah. Anyways, so here's the thing. You got this $1,000, right? Health insurance pays this. Then the hospital writes off this, and so the balance is zero. So my client is up on the stand, and all you get to see is this as the jury.
Right.
This is the $1,000. I hope we're not tainting a jury somewhere. All you get to see is the $1,000, right? You don't get to see this, and you shouldn't.
Right.
Right? Because that is the outcome, not calling balls and strikes, not calling runs, right? You don't get to see this, and you shouldn't because that's not your role, okay? You don't even get to see this, right? All you get to see is this. In Florida, there's the same thing. You don't get to see that this happened, right? But what the clever law that Florida did is they said, listen, if you're going to show evidence of a medical bill, right? They changed the definition of evidence of a medical bill. In Georgia, what's the evidence of a medical bill?
Just a certified bill.
Yeah, it's just a bill. In most circumstances, doesn't even have to be certified.
Just a business record.
You go, hey, you recognize that bill?
Yep.
Yep, authenticated. That's a bill. It's determined, it's deemed to be reasonable and necessary.
Right.
Rebuttable, right? But it's deemed to be reasonable and necessary and legitimate, right? But in Florida, here's how they redefined the definition of damages. They said, the definition of medical damages is not this line. The definition is this line, right? And so what does that do?
It changes the whole damages of the case.
Yeah.
Right.
Right? It changes it dramatically. It just like cut down the value of your damages by, a significant amount.
Just by changing the definition.
By changing the definition. They didn't even get rid of the collateral source rule. You still can't look at how much was actually paid. They just changed the definition of what a medical bill is. But
isn't this problematic later on that you get a judgment and then you have the insurance company trying to come back and collect their $350 that they paid out through subrogation?
No, that's not the problem.
Okay.
The problem is the hospitals.
Sure.
All right, let's play this out. Okay. Let's say that there's this $1,000 bill, right? And let's say that you didn't have health insurance, right? In health insurance issues, if I had a good health insurance policy, okay, no big deal. The hospital's already been paid. They've already got their $350, right? But let's say I don't. Let's say I'm a cash patient. I don't have health insurance, right? Then this is what happens, right? There is no this.
Right.
There's a $1,000 bill, right? Now, in Georgia, if you're the hospital and you have a $1,000 bill, you get to file a lien on my client's case.
For the $1,000.
For the full $1,000,
Yep.
right? And that means that my client has to pay that, or I have to deal with it.
You're required to address it, period.
We've covered this in another episode, but I'll cover it again because it's so important, right? This lien acts just like a lien on your house.
Well, and that's what I was going back to, though, about the jurors in the back room going, well, maybe they only paid $350 or maybe they paid $650. We don't know if there's a lien or not for the whole $1,000.
That's why they're not supposed to guess.
Right.
They're not supposed to be determining the outcome. They're supposed to be determining balls and strikes about damages and about fault, right? Now, what happens in Georgia is that hospital bill acts as a lien, and I have to pay that. And most of the time, I have to pay a significantly higher amount than this.
Right, than what Medicaid or Medicare paid.
Or Blue Cross Blue Shield.
Yeah.
In order to clear that lien.
Because they know you got the money.
Because they know they know that I have to hold on to the money. I can't distribute it to my client until that's resolved.
Right.
All right. So what's going to be interesting to see what happens in Florida is, okay, you've got these hospitals. The hospitals have to be wondering, like, okay, what's going to happen now if they're able to get 80 cents on the dollar, they're able to get 60 cents on the dollar, right? But now the most that the plaintiff can even get is this, maybe 30 cents on the dollar, right? The hospitals are going to get iced out. Unless there's something I'm missing. Whatever the case, this is the big significant thing that
I think if I was the hospital,
did.
I would just file my lien and wouldn't settle it till the case is closed. Period.
Yeah, or there are plenty of other things. The hospitals are pretty clever about finding other ways for people to pay them, right? And so, for example, in Georgia, if my client gets injured in a car wreck and they have Medicare, the hospital can choose whether to bill Medicare or file a lien. Now, it makes more sense for them to do which one?
Well, they'll get more money if they file a lien.
That's right.
Right.
Assuming I can win.
Right.
Right? They could get a lot more money than they would
See
because
Bob Law on there. They're like,
oh,
they're gonna get paid.
Bob Law Firm, he works us over on his client's medical bills, but at least we get more than Medicare would pay.
That's right.
Right. So, in that circumstance, right, Medicare generally is going to pay $180, right? They're paying 18 cents on the dollar. So the hospital's got this choice, right, between, do I get this pittance and I know I get paid?
Right.
Or do I hold off and wait, right? And in Florida, what I suspect is going to happen is that more of those hospitals are probably going to say, let's just go ahead and bill Medicare because we can.
Well, and if that happens, then that change of that definition is significant.
To who?
To the plaintiffs and what they're going to be able to recover.
And?
Their attorneys.
And
the hospitals.
And Medicare.
And Medicare, yeah.
Right? And the health insurance companies.
Who thinks about Medicare?
Right, who thinks about Medicare? I'll tell you, ignore Medicare at your detriment.
Oh, yeah, they'll come get you.
You cannot get away with not paying them.
Right.
Right? So it got so, and here's why. We'll finish with this. There is this statute, there's this code enacted by the United States Congress called the Medicare Second Payer Act. Okay? It was enacted back in the 1980s. And that act says, look, Medicare is not the primary insurance.
Right.
We have clients all the time who say, well, that's what I paid my Medicare, premiums for. They have to pay. Nope.
Right.
Nope, that is not the law. The law is Medicare pays second. And so if there is a primary payer, that primary payer must pay first, right? So let's take that to its logical conclusion. You rear-end me. I have Medicare because I'm old, right? I say to the hospital, here's my Medicare card, pay it. What does the hospital say?
That they're going to, do you have any other insurance?
Right.
Right.
No, it's Dwayne who's responsible.
Right.
He's the primary payer.
Right.
Medicare is the secondary payer.
Right.
Right. We're not going to bill Medicare because they're not the primary payer. Dwayne is. Dwayne and his insurance company. So, and they're right to do that. Now, that begs the question, though. We do see some of our clients who are injured in car wrecks or in slip and falls where Medicare does pay their medical bills. And the question is, well, how does that get done? I dropped my pencil somewhere. Hang on.
So do you think this will result, obviously, when you lower the amount of possible recovery, right, then you're going to lawyers aren't going to file lawsuits on these little bitty claims because it's just not worth the time, effort, and money to recover. So you think this will shut down a bunch of lawsuits in Florida?
No, it's had the opposite result.
It's made them file more.
It made them file more, and here's why. I've told you we're going to get to this.
Okay.
Right, now we're getting to it. It turns out, in our world of Georgia law, whatever the law is at the time of the wreck is what determines your substantive rights.
Right.
For some strange reason, in Florida, it's when you file the lawsuit that determines your substantive rights.
Okay.
So DeSantis and his Republican legislature started making, sounds like, we're going to do this, we're going to do this, we're going to do this.
Everybody filed their lawsuit.
Thousands and thousands of lawsuits got filed, like as retribution or just like doing.
Yeah, they're going to cut our value of our claim in half.
They're going to or more.
Right.
Right. So retribution or whatever, like just preserving my client's rights to say, well, we're going to be under the old definition. Right.
And I've never liked that there's so much emphasis put on the medical bills. Like if it's this amount of medical bills, then.
But I'm missing a pinky. We talked about that, right?
It'd be worth so much more than that. I mean, the pain, the suffering you went through. I mean, that's up to a jury to decide. But I think this is very interesting. I think in the future, though, do you think it'll shut down a bunch of people from filing cases.
No. I think as in any industry, what's going to happen is that the really good lawyers will be fine.
Right.
Because really good lawyers
are going to really good cases. They'll keep making money.
They will handle really good clients. They may take a temporary hit until things, kind of get straightened out. But I don't think the really good lawyers are going to be hurting. What I do think, though, is that you and I are going to be hurting because there's going to be a lot of average lawyers in Florida who have been lazy. And
they're going to come to Georgia.
Yep. They're going to come to Georgia and say,
stay in Florida. It's good down there.
Stay in Florida.
Clean.
That's right. The
traffic here is terrible.
Yeah. Please, for the love of God, don't come to Florida or don't come to Georgia.
Thinking about going to law school, don't.
Right.
Just go get you 2 jobs. It'll be fun.
Be a barista.
That would actually be fun.
Actually, it kind of would. Or
the shop next door to me prints your face on the top of your coffee now.
What?
It's got like some kind of automatic barista machine, and they can give them a picture, and they'll boop, 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 right on your cup of joe.
How does it go again?
Boop, 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 boop.
Boop, 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 boop. All right, very good.
Thought about bringing you one. I just didn't think it would survive the ride.
It wouldn't. You would have to you'd have to encase it in epoxy, and I think that would just probably not be a good taste.
No, but that'd be cool to do.
It would be kind of cool. Yeah. So, all right. So we talked about tort reform.
Yes.
All right. And we talked about what we think the consequences are going to be.
Yeah.
And that's pretty much it. Well, thank you for joining us. We had a really good time talking about tort reform, talking about torts.
And we were just kidding. Submit your resume to www.dwaynesingleton.com. We'll take a look at you.
Or myownKaren.com. File a complaint.
There we go.
Thanks. You can find us. Dwayne, where can they find you?
Down in Griffin, Georgia. Check us out across from Rose's Shopping Center.
And right next to the municipal airport.
Right next to the airport. You can fly your little Cessna right in, land.
Right.
We'll pick you up at the airport.
Or your hang glider, maybe even. Yeah. I'm Ben Benson of the Bob Law Firm. I'm right next to Truist Park where the Atlanta Braves play. And if you've been injured in a car wreck or in a slip and fall, you need to come see me.
Rose's Shopping Center, Brave Stadium, same thing.
I'm just saying. I did one up you.
There we go.
Thanks for joining us.
Thanks for listening. Tune in next time when Bob and Irreverent D talk law.